You hire a licensed contractor. You assume they know what they're doing. You assume that they have their own equipment. You also assume that if they or one of their employees get hurt because they used a broken tool, that it's on them, right? Well, wrong. In many states, specifically regarding rental properties, you're going to be dead wrong, because I'm holding on to a court ruling right now from November 2025 that says if a property owner is 100% liable for a worker falling off a ladder simply because they own the building. And the owner wasn't even there. The owner didn't provide the ladder. The owner didn't deal with the worker that was there. They didn't supervise the work, but it didn't matter. Listen, if you've got equity in your real estate, you're going to be a target for these types of lawsuits. And today I'm going to be showing you the only way to protect that equity when the law decides you're guilty, regardless of what you actually did. All right, let's get started. Today, we're going to talk about something called strict liability and non-delegable duties. And I know that sounds like dry legal jargon and you didn't come here to go to law school, but stay with me, because those two phrases, there's an important difference between retiring on your rental income or losing your properties to a potential judgment creditor. You see, we all operate under this social contract that says if you're negligent, right? If you leave ice on the sidewalk or ignore a gas leak, you're going to pay the price. That makes sense. But what scares me, and should also scare you, is when the law says you're liable even when you did everything right. Now, I want to walk you through this case that just came out of New York involving a simple painting job that turned into a nightmare. And then I want to teach you how to structure your assets so that even if a judge bangs a gavel and says, oh, you lose, and the plaintiff walks away with nothing but a piece of paper because you stripped the equity out of the blast zone before this hit. All right, so here's the situation, the facts of this. And the case is Morales versus Rambley's Real Estate. And here the defendant is a company called Rambley's Real Estate LLC, and they own this building in New York City. Now, like any responsible property owner, they needed some work done, so they hired, a licensed contractor. They didn't try to do it themselves, right? They went out and they hired this third party, New York Painting Plus, to paint some rooms on the top floors. Well, this worker named Omar Morales, who was employed by the painting company, was working on the ladder. Now, according to the court documents that I read, this ladder was defective. It had some worn feet, it wasn't adequately secured, and there was nobody at the bottom of the ladder holding it. So Morales was up about 10 or 14 feet up the ladder when it slid, and he fell back and he injured his ankle, his back, and his knee. Oh, said he was so messed up. So here's where the nightmare starts. So Morales sues the building owner, the LLC. Now, if I were the owner, I'd be screaming at my attorney and say, hey, I didn't buy the ladder. I didn't tell him to climb up the ladder without a spotter. I wasn't even in the room. That's why I hired other people. I don't like to get paint on my clothing. Well, in a normal world, the kind that I grew up in, that'd be a great defense, right? But in the world of real estate litigation, with all these attorneys out there that are preying upon people who they think have deep pockets, and especially some of these cities and states that want to put all this liability on property owners, and they passed regulations and laws, the court is not for you, it's against you. And in that case, the judge ruled that the owner had a non-delegable duty to provide safety devices. That means you can't outsource the responsibility. That means you have to know what the safety code is for someone who is coming out to your property and using a ladder to paint. And the court explicitly stated that the owner is liable even if they didn't control the work. And they granted summary judgment against the owner without even going to a full trial on liability. Now, that's really important here, because what does that mean when they do that? All right. When they grant summary judgment, it means you don't even get to find a jury that would say, yeah, I understand what you're trying to tell the law is, but it's not reasonable to hold him responsible. They just said, hey, we're going to make you liable, and you're not going to be able to see a jury on this. And we're awarding the plaintiff what they're requesting for right away. Now, you might be sitting in Texas or Florida and thinking, well, Clint, that's New York, right? It's one of those crazy states. Look who they just elected as their mayor of New York City. Well, you're right. New York has specific scaffolding laws that are notoriously harsh. But do not tune this out because of that. The concept of being held responsible for things outside your control exists everywhere. We see it with dog bite statutes in California. We see it with environmental cleanup costs. We see it with attractive nuisance laws where a kid jumps over your fence and gets hurt in your pool. I mean, the point is, it's not the latter. It's the legal system that often looks, as I stated earlier, for the deepest pockets to compensate the injured person. And they do it intentionally, right? I learned this in law school. The state wants to shift the burden. They don't want to be paying for that person. They want you, this is the person that has the money, to pick up the costs. Even though it's not, many times as we just described here, it's outside your control. It shouldn't even be your fault. So if the painting company has limited insurance and they go bust, then they make sure they've got someone else on the hook for that. That's how they see you. Person with deep pockets that can pay. They see your property, they see the equity, and they file a lawsuit. In this case, the court said the owner's lack of direct supervision and control, as they stated earlier, was irrelevant, and contributory negligent, meaning the fact that the worker might have been careless, it wasn't a defense. Because, the next thing I'm going to argue is that, hey, that guy climbed up the ladder. He should have known better, right? Or maybe he's up on the ladder standing with only 1 foot on the rung and trying to reach and paint something in a corner, right? To cut in a corner. And he was leaning out over, being stupid rather than just moving the ladder because he didn't want to get down off the ladder. And that's what caused him to fall. Doesn't matter, right? So you can't win a lawsuit because many times the law is stacked against you. So what do? Well, you make sure that losing a lawsuit doesn't mean losing your wealth. And that's what I'm going to show you right now. And this is where we separate the rookies from the pros when it comes to real estate investing. Most of you know you need a limited liability company. And in this case, the defendant actually had an LLC. But by holding property in an LLC, the owner of that company protected their personal assets and their bank account and things like that. But they were suing the limited liability company. And so they had a lot of assets inside the LLC, the equity in the property that they could go after. And if that wasn't enough, if you don't run your LLC the right way, and again, on my YouTube channel here, be sure to check it out because I have some videos discussing how to prevent piercing the veil of your company. They can sometimes reach through the LLC and hold you personally liable. So here's the issue that we faced in this case is that you have an LLC right here that owns a building inside of it. So the person that was hurt down here, right? So he's going to come into court. Of course, he's going to be in his wheelchair and claim he can't get out of it because he's really hurt. He's suing this limited liability company. And as I stated, the court just saying, boom, LLC, you're automatically liable. So if this property right here has $300,000 in equity in it, then this plaintiff is going to be able to get this equity in the property plus your insurance if they're successful. So what we need to do then is discourage plaintiffs like this from suing our companies that own our real estate. Now, how do we discourage that? Well, when I say discourage it, that's an improper term. You're not going to be able to necessarily discourage the lawsuit. What we want to do is encourage settlement of the policy limits and not go after the property itself. So how do we encourage them to go after the insurance and leave our property alone? Well, in order to do that, we have to wipe out our equity. We have to make it appear as if the property has no equity in it. That even if you win, you lose because you can't collect. Now, the simplest way to do that is to set up a Wyoming limited liability company. Now, the reason I'm going to do Wyoming over here, okay, is because Wyoming offers you anonymity, meaning that if we have the same owner, this company is owned right here by Clint, and this one's owned by Clint. This one here is in New York. They know I own this company, but they don't know I own this. And that's critical for this strategy here to work for you. So what we're going to do then with our Wyoming LLC that doesn't trace back to us is we're going to have this LLC agree to loan the property LLC $500,000, okay? So it's going to enter into a line of credit agreement with the New York LLC for $500K. Okay, stop. You're probably thinking, I don't have $500,000 that I could put inside of an LLC to do this strategy. You don't need that. This strategy is based upon perception and not reality. That's what makes it so effective. Because when we enter into this line of credit, agreeing to loan the New York LLC from the Wyoming LLC $500,000, we're going to ask the New York LLC to give us a deed of trust against the property. So now this $500,000 deed of trust or mortgage that gets recorded against the property shows up as an encumbrance. So when plaintiff looks at the LLC here, they see the property, but they see it's underwater by $200,000. Because remember, originally I said it had $300,000 equity. Well, when you drop the $500,000 lien against it, now you just reverse that. Now it's upside down. So think about this if you're the attorney representing Morales. Would you encourage him to go after an LLC after a property that has no equity? I think not. Now, for some of you that like to be the contrarian and challenge everything, you might be thinking to yourself, well, all I have to do is get Clint you under oath and I can ask you if there's any equity in the property. You have to tell me. Actually, I don't, because that's not relevant to whether or not I was negligent or not. So in this particular case, this is one strategy to get them to look to the policy limits to force a settlement rather than having them look to the property themselves. So it gives you negotiating power. If you don't do this, listen, it's wide open. All they have to do is they know that if there's equity in the property, straight path to that equity, especially when you have judges that are willing to give out these types of summary judgments against you. What we want to do is we want them to move towards the insurance company and take the policy and then give us a release and leave us alone. Now, if you're listening to this and you're realizing you have a lot of naked equity sitting in your properties, that is a problem that you need to fix. And this isn't stuff you can set up on your own using, the legal dooms of the world, okay? They're not going to have the templates. They're not going to show you how to set this up the right way. Listen, my team has been structuring deals like this for our clients for over 25 years, and we've been protecting their equity from situations like this. Now, is it 100%? No. If he still proceeds against your company and he gets a judgment against it, can they find out that you never loaned money and it won't protect you? Yes, but that's not the point. 9 times out of 10, this makes that case go away because they assume there's no assets there and it protects your wealth. So you see where the risks are. If you know you have the risk and you want to build a fortress around it so a broken ladder does not cost you your retirement. Hey, if you want to learn more about strategies like this, I'd love to invite you to our free 1-day real estate tax and asset protection workshop. We teach these on Saturdays. It's one solid day of learning about how to put structures together like this to protect your wealth. More importantly, we also discuss how to use the tax code to put more of that wealth back into your pocket and avoid Uncle Sam at the same time. And if you've got questions, bring your questions because we bring our attorneys to make sure we're getting your questions answered as well. Go to the show notes, click on that link, register. It's completely free, and I hope to see you on our next event. Take care.